Hi there, everyone. I think we'll get started now, so we don't keep you too late this evening. My name is Eileen. I am a director on the board for CCI Eastern Ontario, and I'm going to be your moderator for this evening. So thank you, everyone, for joining us. We have quite a nice, large turnout, so thanks, everyone, for coming by. Before we get started, I wanted to go over a couple of Zoom procedures for everyone. We're recording this event this evening, so it's going to be available on our CCI Eastern Ontario website for you to have a look at after and share with any of your colleagues on your boards. Our audience is muted and your videos are set to off during the presentations. We're going to ask that you please use the question and answer feature to ask any questions, and that's at the bottom of your screen. Don't use the chat, we're not going to monitor that, but please use the question and answer feature. All questions, we'll review them at the end of all the presentations, so just hold tight for us, but feel free to type your questions at any point during the presentations, and we'll definitely get to those at the end. I just want to let you know that the information you are being provided here today is general information, and the primary purpose of this webinar is to educate and inform. The webinar does not constitute professional legal advice or services. Please consult your corporation's legal counsel for an opinion about your specific situation. This webinar is not intended to provide you with opinions that would protect you as a director under Section 37 of the Act as well. Please be advised also that any references to the Condo Act or any other legislation is in reference to Ontario legislation. Okay. Before we get started, we're going to do some big thank you to Christy Allen on your screen there from Davidson Houle Allen for being a presenter this evening. We have Gareth Stackhouse as well. There you are, from Common Ground Condo Law. And we also have John Fitzgerald from Apollo Property Management. Thank you guys so much for agreeing to help us out this evening. Really appreciate it. I think everyone's going to enjoy the presentations. Also wanted to say thank you to our sponsors for this event this evening. We have Carleton Electric, Common Ground Condo Law, Elia Associates Condominium Lawyers, Upper B, and World Financial Group. Thank you to you guys as well. Very much appreciate your sponsorship. So Proxies forms, oh my. So this evening, our experts are going to help you navigate those pesky condo forms. We got so many of them in the last years. We're going to look at what we do with those. Questions and confusion surrounding the proxy forms, the other condo forms are all too common. Some of the forms are mandatory, some are optional. We're going to learn what those forms are for, which ones are mandatory, when to use them, how to complete them. And now more than ever, it's important to understand these forms. So we thank you guys all for being here this evening. And we'll take the opportunity for questions and to learn what we can to do with all these forms. Oh my, excellent. So we're going to start this evening with Gareth, who's going to talk about forms related to meetings and voting. Over to you, Gareth.
Excellent. Thank you so much, Eileen. Great to be here with you folks tonight. Eileen also mentioned, or may have mentioned, we've got some polls going on. Eileen, would you like to mark or launch the first poll for this evening? Thank you so much. We just would love to know how you feel about the forms. There's a few different answers there. Let us know. And this is how we're going to be informing you tonight. Obviously, we have to have form puns. Go over the meeting and proxy forms, all the different certificates that are mandatory under the Act, all the forms relating to records, and then we'll lightly touch on some of the other forms. Highest level about condo forms. Most are mandatory, but not all. They're set by the Act and the regulation. The optional forms are highly recommended, and there's been some recent case law that maybe you ought to be using optional forms all of the time. Fill them electronically. All of the form, or almost all of the forms are electronic, especially the kind of core 19 forms the CAO maintains. They expand, boxes pop up, really, really important. And please use the up-to-date forms. Get the up-to-date form from the repository. Please don't be using forms that were out of date 2 years ago. Where do the forms live? I just said you got to go get them. 2 places, the CAO, Condo Authority, has some, and then the Government of Ontario maintains a few in the Land Registration Portal. Maybe we could end that poll now and see how everybody feels about the forms, Eileen. So your CAO forms, you've got forms relating to meetings and votings, information certificates, records, additional forms, status certs. You click the lovely little arrows, they expand, there's more information. Tolerate, okay. 65% of our respondents tolerate the forms. 4 of you said what forms. Only 1 person loves them, and I'm sure that was a typo. So thank you very much for that. The other forms, and these are basically forms that only lawyers care about. They live land registration documents. This is technical stuff, such as dissolving a condo, but it's also where you find all your lien forms and things like that. You won't use them very much. Our meeting forms, they're mandatory. We've got 3 of them. Your preliminary notice, your proxy, they all work together. If one form isn't filled out right, the other ones fall away. They have to be consistent from one to the other. And they've got to have all the right info in them. So your prelim notice, section 45.1, that was a new section of the Condo Act a few years ago. 20 days before the meeting, please give yourself time when you send this form out. Don't jam yourself up. I was recently at something where our AGM ended and the manager said, well, I'm going to be here till 3 in the morning getting this prelim notice out. Please, please, please give yourself time. You cannot count the sending day. You've got to plan in terms of the dates for submissions by candidates for owner material. And so important, if you don't fill out your prelim notice right, you can't then go and add something on the notice that wasn't contained in the prelim notice. You will actually have to restart your meeting process. Your prelim notice is not required in a couple places, namely for loss of quorum meetings or requisitions. So let's take a look at a form. We've got our condo here, OSCC 5001. There's a meeting, Feb 24, that's today. Briefly, a couple things that have been filled out in this that are really important. You've got the way to contact your management office at the condo, or you can email John. He's your property manager. Summary and purpose of meeting. You got to hit the highlights. AGM, we're also doing some deck and description amendments. We're doing a bylaw. This is a substantial change. And then that's got to be reflected and ought to be reflected in part 4. We're doing all these discussions, proposed changes, declarations, bylaws, and agreements. We're doing our section 97 changes. You've got your director information about the number of director positions that are up. You can see that we've always, it's an AGM. You're going to appoint an auditor. You appoint your auditor every year. That's required under the Condo Act. Please make sure you check off all the boxes about your auditors. You're going to see some dates in here as well about delivering intent to be a candidate, appoint an auditor. There's going to be one over here where owners can submit materials. It's very important that those dates be in there. They actually have to be 15 days from, at least 15 days after the prelim notice is sent. Recommend you give yourself enough time, make all the dates the same so you're not confusing yourself when you fill out your forms. And then we've got some data about section 97, obviously substantial changes. You've got to put that in and those boxes expand. And then there's an optional anything else. You know what? Condo's got a new privacy policy. May as well send that out with these documents as well. That's a really brief overview of your prelim notice and meeting form. Okay, you've done that. You've waited your more than 20 days. It's now time to send out your notice of meeting form. Again, please fill out everything and attach everything. You didn't have to attach the copy of the bylaw, the copy of the deck amendment to your prelim notice. You do have to attach it to your notice of meeting. That is required under the Condo Act. Always remember that. And please, again, remember your auditor. You've got to do this 15 days before the date of your meeting. Again, give yourself time. You can't really count the day you send the form. So please, please, please give yourselves time when you do this. This form that we're going to look at, there is actually a different version of this form. It's only for loss of board quorum and meetings, and that's only where owners call the form. That is, if that ever happens in your world, super important. There's a recent condo case where the court actually tossed a requisition, or sorry, a meeting because the right form wasn't filled out. And just under the current emergency provisions, if you called a meeting in person for some reason and say our restrictions, you guys are in Ottawa, get rolled back, you've got to go virtual again, there's not a need to send out a new notice of meeting if you have to change how you're holding the meeting under the current emergency restrictions. Again, here's our form for our condo. 1 point, please always use the full legal name of the condo corporation. Don't use the short form. Section 2, this would be a great place for the government to update forms because we have to put in virtual meeting by webinar, details and meeting package. You don't actually have enough space in this little box to get all the details about your Zoom or whatever form you're using for virtual meeting. Again, we've got your nature of your business, and then we say, see attached agenda. There's always more in the agenda. Get your quorum. Obviously 25% of units, but double check your general bylaw and make sure that's right. Section 5, if you have an electronic meetings bylaw, you will fill out section 5. There's another way to be here. You can be present. We count you as being here by virtue of bylaw number 8 or e-meeting bylaw, and you can vote under bylaw number 8 or by electronic ballot. Section 8 is kind of the money piece of this. You've got to check off everything that's going to happen. So AGM, check. Financial statements, auditor's report, great. You've elected directors, 8B. You've listed your directors. You've listed a number of positions. When you list directors, just as a practice point, I always just go by or recommend that folks go by alphabetical order of either first or last name, whichever works. 8C, again, auditors. You're going to appoint an auditor. It's an AGM. Please check 8C. Problem with the form. And goodness knows there are problems, and we'll get to those at the end of this presentation. The moment you check 8C, it says, hey, why are you removing an auditor? Well, we're not, but that's a problem with the form. So just no auditor proposed to be removed. Auditor that you've got, put their name in. Hey, that's who the board's recommending. Great. And then because we're doing section 97, substantial change stuff, we filled this out with our data about what we're going to do. I am looking forward to that water slide. 8F, hey, changes, declaration, description, bylaws, and rules. Check that. Copy of everything has to be attached to your meeting package. And then bylaw number 10, or sorry, section 10, pardon me, this condo has a special bylaw. You've got to include photos of all new puppies every time you have a meeting. That's how they did it. They like their dogs there. It's sent out, boom, you're done, and you include the privacy policy. So that's a very high level overview of your meeting forms. And we're going to launch another poll right now, Eileen, please, about the proxy form. How much do you like your proxy form? The proxy form, of course, has to be attached to your notice of meeting form as part of your meeting package. There we go. There's a few different options for the proxy form. I'd love to know what you think. Even if you're accepting electronic proxies, and I have to note, you don't have to have an e-meetings bylaw for electronic proxies. You do right now always have to accept paper proxies, which of course creates headaches. And that's a kind of logistics and planning point for your meetings. Proxies, a couple key points from section 52 of the Act. A person's got to appoint a proxy. So I have to appoint Christy to be my proxy. There has to be a physical person there to hold on your proxy, whether it be electronic or paper. It's got to be in writing. It's got to be signed either electronically or in wet ink. It's got to name the meeting, and it's got to be in the prescribed form, which is, again, why we're here, prescribed forms. Generally, and especially with paper proxies, they're more prone to error than electronic proxies. Most lawyers, condo lawyers who are chairing a meeting will try to enfranchise as many people as we can. If we see kind of some of the typical errors where it hasn't been filled out right, we will do our darndest to make sure that if somebody's voted for something, that they're counted. Thanks. I think we can close the poll now and see how much people love or like proxies. Thank you so much. Okay, overwhelming UGG, 42%, and they're about as fussy as getting dressed for an Ottawa winter. Nobody thinks that they're about as fun as this presentation though, so I appreciate that. Problematic proxy parts. There's a couple of key parts that always trip people up, and these are the parts that aren't filled out right, and we look at them, we're like, did this person vote? Name of proxy. You have to appoint somebody to hold the proxy. Please, 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 when you do a proxy, be it electronic or send it with your meeting package, put a default in here. It can be something like this. So somebody can sign right beside it. The president of the condo is my proxy holder with full power of substitution, which means if the president can't show up, somebody else can hold the proxy. Please, please, please always make sure that is done. Your other problematic proxy parts. These are kind of the 3 boxes of heck. How is this proxy going to be used? Box number 1, if they check this, it's only quorum. They should not have the ability to vote, but all the voting stuff still shows up. Box number 2, check that. The proxy is used for quorum and routine procedure only. Again, none of the voting for directors, bylaws, whatever, none of that should show up, although it does, and none of that can be counted. And then finally, if somebody wants to vote for everything that's happening at the meeting, they have to check box number 3. This is a key pain point. We often see proxies where they've checked box 1 or box 2, and yet somebody's voted. Please make sure, or educate whomever you're talking to about this as to how they can fill this out so that their intent and their will is carried out. One other point, of course, is if box 3 is checked, potentially the proxy holder can get ballots at your meeting, depending on what the instructions are that are laid out in the proxy, i.e. if somebody's checked box 3 but hasn't voted for directors, totally fine to give that proxy holder ballots. This is a pain point at meetings where you've got electronic voting. How do you give somebody additional electronic ballots? Talk to your e-meetings provider about that. So our proxy form for our OCSCC 5001 meeting, pretty simple. I did want to highlight right at the bottom, there's our copyright date. So this is the newest form done in 2018. We're still seeing 2017 forms. Please check if you've got the newest form. Here's our little 3 boxes, problematic boxes. As tempting as it is to pre-check a box, you can't. Please do not pre-check a box. You can see that we've got our president or our default proxy holder. We've listed our candidates. And then we've got a bylaw vote. Great, yes, no vote. We've got a section 97 substantial change vote. Yes, no vote. What you don't see here is, there's nothing here. Declaration changes. Obviously, that's consents collected after the meeting, which is not a mandatory form, but potentially should be. But there's a proxy. Covered this, e-proxies, please check the inputs. So if you're using electronic proxies, go take a look before your meeting, well before your meeting, make sure that they've captured everything, that it agrees with your notice and your prelim notice. There's a default proxy holder. We're seeing electronic proxies that don't have a default holder, and make sure they output into the proper format. And when I say proper format, I mean they can output an electronic version of the proxy form. If you need it, that's a record of the condo, which John will talk about later on. Okay, we've got another poll for you about managers and proxies. Just a little bit about what you think managers can and can't do with proxies. Let you fill that out. Managers and proxies regulated under the Condominium Management Services Act, sections 53, and then part of the general regulation. What can you do? I'm going to spoil it for you if we can close the poll, please and thanks, Aline. Great. Nothing except provide and collect them was a majority of the respondents. And then a little bit less than a majority said, oh, okay, you can provide, collect, remind, solicit, voting, blah, 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 certain items. The folks in the minority were actually correct. Managers cannot solicit for the removal or election of directors. And you can't solicit for anything to do with the manager or management company if there's any voting about that. But you can circulate, notify, and remind and give owners info about how to fill out proxies. I know we've got a few managers in our audience tonight. It's an education thing because the proxies are, as we've seen from a poll, a royal pain in the whatever to fill out properly. You can collect the completed proxies and you can solicit. Managers can solicit for quorum only, for bylaw votes, for section 97 votes. That is permitted. And quite often, especially if you've got a bylaw vote and it falls short and you adjourn that part of the meeting to see if you can collect more proxies, managers can be key in that. So that's it. I'm going to hand it over to the next person in our stack tonight, and I believe it's Christy.
you for being here with us this evening. We weren't sure what to expect when we signed up to do a seminar on forms, but obviously it's a popular choice, and we're glad that it is because we find it interesting too. I'm going to go ahead and share my screen as well and carry on with the presentation. I hope I do this correctly. Sometimes I run into problems. Okay. All right, so I'm going to take on part 2 of this presentation, and really what I'm going to be covering are here. There we go. Information certificates and status certificates. So these are 2 sort of confined areas of the forms, and I suspect that most of you in attendance this evening are probably familiar with all of these forms in one way, shape, or form. So Garrett did promise lots of form jokes. So I hope that I'm not repeating information that you've already got, but hopefully you'll pick up little things here and there if you're already intimately familiar with these forms. So as you can see here, I'm going to be covering the 3 types of information certificates that are prescribed under the Act. And I'm going to be talking as well about the notice of online posting of information certificates, how that's done and when it applies, and then status certificates. So we will start with our information certificate forms, and I'm going to start with the periodic information certificate. Just to go back for a moment, the 3 types of information certificate forms, just to be clear, the periodic information certificates, the information certificate update, and then the new owner information certificate. And I'm going to explain all of these. So what is the periodic information certificate? We often hear this referred to as a PIC. So what is a PIC? PIC is a mandatory form, and it's really intended to keep owners informed generally about certain key pieces of information with respect to the condominium corporation. It's a prescribed form, so the information that goes into the PIC is prescribed, meaning that the ministry has created the form that tells us exactly what boxes to check off and what kind of information to include. But condominium corporations can pass bylaws to add to the information that they're required to provide through the PIC to the owners. And just to provide you with the context for why the PIC came into existence, prior to the PIC and prior to the existence of information certificates in the condominium world, there was no formal requirement that condominium corporations update their owners in terms of what was going on in the condominium corporation. So there could be significant changes or changes that are relevant for all owners. So for example, changes in the directorship, vacancy on the board, and an appointment to that vacancy. There may have been lawsuits launched against the condominium corporation. These are pretty key pieces of information for owners within a condominium corporation, and none of that information was relayed to owners. And often what was happening is the information would reach owners at the annual general meeting when the annual report was provided. So in an effort to encourage the flow of information to owners, the information certificates were created, and this periodic information certificate in particular, which is aimed at owners, was created to encourage that flow of information, even though I'm sure many condominiums were doing that as it was, but this now prescribes it, it requires that. When is the PIC required? The PIC is required twice every fiscal year. So within 60 days after the end of the first quarter of the fiscal year, and within 60 days at the end of the third quarter of the fiscal year. Condominium corporations can pass bylaws to increase the frequency of PICs, but I'm not aware of any, none of my clients have done this yet. So it's just something that maybe in certain circumstances condominiums might feel is helpful. There is an exemption applicable and available to condominium corporations with respect to information certificates. And the exemption applies if you get 80% of unit owners to consent in writing, and it has to be after the turnover has occurred. So the exemption can't apply during the period when the declarant controls the board. But once the board has been turned over to the purchasers and the owners, if 80% of the owners consent, 80% of the owners of units consent to doing away with the need for information certificates, the corporation will be entitled to an exemption. However, it's important to note that the exemption will only apply for the duration of the fiscal year. So if you were to get 80% of the owners to consent to an exemption today, it would only be applicable until the end of the current fiscal year, and then you'd have to repeat the exercise. So it's quite cumbersome for larger condominium corporations. This was really aimed at assisting those smaller condominium corporations where virtually all of the unit owners are already engaged in one way, shape, or form, and they have all of the information that they would typically be getting through a PIC. I can think of a number of examples of small condominiums under 10 units where it just simply wouldn't add anything. And so it just creates an unnecessary technical burden on those condominiums, especially where they're self-managed. So I'm going to go into the form itself now. So this is what the PIC looks like. This is page 1 of the PIC. I'm going to take you through it. But again, I know many of you are already familiar with this, and there's a lot of this that's really not rocket science. So I do apologize if I bore you with any of this. So we'll go through section by section. Section 1 is general information about the corporation, which just includes information respecting the name, address, manager of the condominium corporation. I followed Gareth's lead. Gareth, you'll notice I'm using your condominium corporation for your meeting that took place tonight, and our trustee manager, John Fitzgerald of OCSCC 5001. And just so that you all know, there is no 5001. We're still in the thousands at this point. So this is just a pretend condominium corporation that we're using for these forms. This also provides information to owners with respect to how they can communicate with the corporation electronically, and also provides information respecting how many units are leased, how many units the corporation has received notice have been leased within the corporation. I apologize that this is a little bit squished together, and I hope you can all see it, but section 2 of the PIC is really just a list of the directors and officers of the corporation, and the addresses for service for each and the emails for each. Technically, the actual address of each of the directors is required to be included as their address for service. I know sometimes it is the manager's address that's listed there, and unless owners object, there's nothing wrong with that. But technically, it's the address for service of the individuals that's to be included there. And then within this section, you would check off if any of these directors are a party to legal proceedings involving the condominium corporation, or if they're in arrears of common expense payments. So that information will go in there, as well as whether or not they've completed the prescribed training within the prescribed time. So directors are now required to undergo training or undertake training within 6 months after they're elected or appointed to the board. If they don't, they're automatically disqualified. So I find D interesting within the context of the PIC, because technically if a director hasn't complied with the prescribed training, they are automatically disqualified as directors. So technically they wouldn't be listed here, but I think it's probably just to alert owners to the fact that the individual hasn't completed the training and is therefore perhaps no longer a director. Section 3 is the information that sets out the insurance policies that are in place at the condominium corporation. So here is where you just confirm that all of the policies you're required to have are in place. And you would list the individual policies that you've got, and then the individual deductibles within each policy to the extent there is a deductible. And then, of course, to the extent an owner could be held responsible for a deductible, which would relate to the property insurance policy, you would include there the maximum amount for which they could be held responsible. And then the rest are just affirmations that the corporation has obtained the required insurance policies. So insurance policy maintained under Section 39 of the Condominium Act is the D&O policy. Section 99 is the property policy, and 102 is the comprehensive general liability insurance policy. So you're just confirming there you've got all of those in place. And then you're confirming yes or no, whether or not there's other policies the corporation is required to maintain. This is also the section where you're confirming whether or not there's a standard unit description for the corporation, and that, and if so, which bylaw would have that description. And then here, you're also confirming that there's a certificate of insurance attached to the PIC. So with every PIC goes the certificate of insurance for the corporation. Financial information for the corporation is section 4. And here you're just letting people know whether or not you're on track in terms of the budget. So whether or not there's an anticipated surplus or deficit or neither. The reserve fund balance and the reserve fund contribution, as well as the anticipated reserve fund expenditures, all go into this section. It just gives people an idea of where the corporation stands with respect to its reserve fund. And then And then in terms of section 5, which is also on this slide, that deals with legal actions relating to the corporation. So here, this condominium corporation is a party to an action. They've sued their developer, it looks like, and you provide the status of the claim, just a little brief status explanation. If you have a lawyer acting for you, obviously they can provide that status update for you. Because this action involving our condominium corporation here is a claim started by OCSCC 5001, this claim wouldn't be covered by insurance. You can't get insurance as a plaintiff to cover your, you wouldn't be seeking insurance coverage. You'd only be seeking insurance coverage if you've been named as a defendant in a lawsuit. So here we're saying that we haven't reported this to the insurer. We haven't made a claim for payment from the insurer. But if the corporation is a defendant, then you're required to provide owners with information as to whether or not the claim was reported to the insurer and whether or not the insurer is responding with to confirm coverage and or is covering the legal fees. So that information all goes into this section. And then here we have section 6, 7, 8, 9. These are just the finishing up sections of the PIC, and they're pretty self-explanatory, but section 6, outstanding judgments relating to the corporation, that would be if there's a judgment that hasn't yet been dealt with or satisfied, you would list it here. Disclosure information that is going out with the PIC. So if directors are required now, as probably most of you are aware, to provide a disclosure statement at the time that they're being elected. They're also required, well, or within 30 days of when they're elected. So that's the actual time frame. They're also required to provide updated disclosure information if anything changes in terms of their disclosure that they previously provided at the time of their election. So if there are any changes, if they become a party to an action involving the corporation, or if they become a party to a commercial transaction involving the corporation, that needs to be updated. So they need to provide further disclosure to the corporation, and then the corporation would attach that additional disclosure information, as well as any disclosure statements received at or after the AGM, along with the PIC. Compliance information with the corporation. This is just confirming that you filed the returns required by the CAO, that you have complied with the assessment obligations, so the payment to the CAO for the CAO's fees. And then finally, other information with the corporation that's required by a corporation's bylaws. Again, because you can add to what you want to include in a PIC by way of bylaw, this is where that additional information would go. All right, we're on to the information certificate update. So we dealt with PICs. Now information certificate updates are really, the intention of the information certificate update is to provide owners with information if there are certain key changes to certain pieces of information relevant to the corporation between the timing of the PICs. So if after a PIC is issued, a few weeks later, you become aware of a change in the directors, as an example, that is going to trigger the requirement for an information certificate update. So I'm going to take you to the form in a moment, and that is the form actually lists all of the areas that would trigger the requirement to provide the information certificate update. But basically, once the change happens, you have 30 days from when the change occurs to issue the information certificate update. We'll go to the form here, and you can see items 1 through 8 are listed. These are the areas in which, if there's a change, you're required to issue an information certificate update to the owners. And so it is changes. The main things that are going to affect many condominiums are changes in the directorships, changes in the condominium manager, and then changes in the corporation's insurance deductibles or termination of insurance. Number 7 is vacancies on the board and no quorum. So a vacancy on the board doesn't trigger the need for an ICU, information certificate update, unless a new director is appointed. And then once the new director is appointed, that's a change in the directors, and that requires an information certificate update to be issued. But if there is a vacancy that results in a loss of quorum, then this information certificate must go out, and then the remaining board members, the only authority they've got left is to call and hold a meeting in which to elect new directors. All right, speeding right along here to the third of our 3 information certificates, the new owner information certificate. I know some people like to call them NOICs in our office. I don't know if other people call them that, but so the new owner information certificate, unlike the periodic information certificate and the information certificate update, which go to existing owners within the register of the corporation, the new owner information certificate only goes out to new owners and only when they've alerted the corporation to the fact that they're a new owner. So they provide the corporation with their name and their unit. And I'm going to show you what it looks like, but it's really, really straightforward. Basically, you're just checking off that you're enclosing a copy of the most recent periodic information certificate, as well as any information certificate updates that you've sent to owners after the last periodic information certificate went out. And then if you do have a bylaw requiring additional information to go out with the NOIC, as I like to call it, that would also go along with that. All right. The notice of online posting of information certificate is effectively a notice that is useful in the context of this information certificate discussion. And effectively what it is it allows a condominium corporation to, instead of issuing a periodic information certificate or an information certificate update to each and every owner every time one is issued, you can simply issue a notice of online posting alerting owners to the fact that you have posted electronically on a website the most recent periodic information certificate, or that you've posted an update, information certificate update. And so the requirements are listed here on this slide, but effectively what you need to do is the information certificate has to be posted on a website, and that it must be accessible by owners. The notice of online posting is sent to owners either electronically if they've agreed to that, or in paper format. And the information has to be included instructing owners how they can access the information certificate that has been posted. The third point here is just that the posting has to remain accessible for a full 30 days after the notice has gone out to owners. So I'm going to show you what this looks like, but it basically does, this is the form here. It's pretty straightforward and it's very simple. So instead of issuing again the periodic information certificate or the information certificate update every time to all owners, it's, you can choose to just issue this form as long as you're able to make those other information certificates available online to owners. This just provides a little bit of information to owners, instructions on how they can access it. And that's all you really need to do. Leave it available for 30 days. All right, I'm going to move into status certificates now. This is a certificate that probably everybody is familiar with. It obviously has lived longer than the information certificates and many of the other forms that we're going over this evening. So I know that most of you are familiar with it, so I'm not going to spend a great deal of time on it. I'll just make a few, I am going to take you through the form again. I felt like this was a form seminar, so I needed to actually go through the form for some reason, but we won't spend a lot of time on the sections of the form. I'll try to highlight the main points. So the status certificate is directed at purchasers, whereas the information certificates that we just talked about are directed at owners. So that's a big difference in terms of the audience of these different certificates. So the status certificate as a result contains similar information to what's in the PIC, but not identical. And one of the main areas of difference is that a purchaser is they're interested in knowing what the status of the corporation is, what the reserve fund balance is, if there's common expense arrears, all those kinds of things. But they are also interested in knowing what the financial liability or potential liability attaches to a purchase at the condominium corporation. So, this is the kind of additional information that's contained in the status certificate that is sort of unique to those who purchase. Generally, these are the areas that are covered by the status certificate. I won't dwell on them. Status certificates have to be issued within 10 days of receiving a request, and that's 10 days, not 10 business days. And it's important to note this because if a status certificate goes out after 10 days, after it's been requested, then it's deemed to effectively be clean, to contain statements that say there are no arrears, there's no risk of increase in common expenses, and there's no special assessments that have been levied. Now, that may be the case for the particular condominium, in which case there's no harm, no foul, but for any condominium corporation where there are arrears or there's a potential for an increase in common expenses, that has to be disclosed within that 10-day time frame. Otherwise, it does present significant liability to the corporation, which we want to avoid if possible. Anyone can request a status certificate. We get that question a lot. That the Act doesn't specify that it can only be requested by purchaser, an owner, or anyone, an agent for one of those. It can be anyone. So anybody at all in the world can request a status certificate for your corporation. And as long as they pay the prescribed $100 fee, they're entitled to receive that. We also get the question, can they be shared? A lot. They often, I know it's a common practice that vendors, agents will request a status certificate and then give it to interested purchasers so that they can make offers on an unconditional basis. Generally speaking, when a status certificate is issued, it's safest just to ensure that the information is accurate. There may be people that you're not aware of who are relying on that. And I think there's a good argument that they're not entitled to rely on it, but the issue is not crystal clear in law. And so it's always obviously better to just avoid any potential liability by ensuring accuracy. As long as it's accurate, it doesn't really matter who's seeing it or who's relying on it. All right, so this is it. This is the status certificate form. Again, I'm not going to dwell on, I just felt the need to show you, I'm sorry, here it is. But I am going to stop here, the budget section. So the budget section, this obviously includes information about whether or not you're on track in terms of the budgeting and whether or not there's any special assessments that have been levied. But paragraph 12 is the main paragraph that I like to highlight. And it's a favorite for lawyers because this is where the corporation's liability is really focused when a status certificate is issued. So paragraph 12 obligates a condominium corporation to disclose any information that could give rise in an increase in common expenses or a special assessment. So you don't need to know for sure that the information you've got is going to result in an increase. You don't need to know the amount. You don't need to know the timing. You don't need any of those details. If you have any information that indicates that common expenses could go up, then that information needs to be disclosed. And that includes, for example, if you have an engineer who's on site overseeing a project that's planned and funded, and they notice something, they're opening up walls to replace windows, and they notice there's something off about the construction of the building. And they mention this to you and they say, we've noticed that there's this issue within the walls. We think we should probably take a look at a few more to see if this exists elsewhere. That information, not the specific information, but that information does present a risk. That indicates that there's a potential liability to the corporation, being the unknown risk of the results of whatever that investigation is. So if the engineer comes back after investigating and says, yep, we've got a systemic issue, you've got to replace whatever it is. Sorry, I'm not a technical person, so I don't know I can't come up with the language on the spot, but if they tell you ultimately that major work has to be done to address this issue that they identified that one day and passed along to you and just verbally, then anyone who's purchased and gotten a clean status certificate between that first notice from the engineer and when you get the written report confirming, yep, it's an issue and it's going to cost you $2 million, they could have a complaint against the corporation. So it's just important, again, to note that any information that you've got needs to be disclosed. The details, again, don't need to be disclosed, and the wording can be massaged, but it's just a matter of identifying that there's a potential risk here for purchasers, that there's an issue that's being identified or investigated, and it could result in an increase in common expenses. We often see this come up with respect to draft reserve fund studies. So when a corporation receives a draft reserve fund study, that indicates there's going to be an increase in common expenses. Sometimes that information doesn't find its way into the status certificate until the notice of future funding has been approved and issued by the board. In fact, once you receive a draft reserve fund study, that indicates there's likely a required or possibly a required increase in common expenses or special assessment. That has to go right into paragraph 12. And you can use wording like, we've received a draft reserve fund study. We don't yet know how this is going to impact common expenses, but we anticipate potential increase. That general kind of wording is just fine until you've got more concrete information to provide to purchasers. All right, I'm going to speed along here through the form. So most of you have seen this. If anyone has specific questions about what's in the status certificate, happy to answer those at the end. So we'll just keep moving our way through here. This is the list of attachments, also very important to ensure that all of the attachments are in fact attached. Many are not applicable, they'll be struck out, but to the extent you've got them. All right, so as I've said, paragraph 12 is the main area of concern for purchasers and condominium lawyers alike. Generally, status certificates are prepared and issued by the managers, but they should always be reviewed and approved by the board at the board's monthly board meetings, just to ensure that the board is aware and that the board has a chance to say as a collective, okay, has anyone become aware of any information since the last time we reviewed this? And you can have that discussion to ensure that it's always kept up to date. And I wanted to make a note about issuing certificates for multiple units. If you're aware that a residential unit has attached to it a storage unit and or a parking unit, it's a good idea to make reference to all three within the status certificate that goes out, even if a request has not come in for all three. Perhaps the request has only been with respect to the residential unit. It should always relate to all three, because if there are arrears attached to the units that are not addressed in the status certificate, then the purchaser may go ahead and complete the purchase and not be aware of those arrears, and they might not be taken care of. And then there's question as to who's responsible. So best to avoid that situation, just to include disclosure within the status certificate. And I also wanted to mention that paragraph 12 is a bit of a catch-all. You can mention other things, other non-financial items. For example, if the board has proposed a rule limiting short-term stays within your condominium corporation, but it hasn't yet become in force, it hasn't been approved by the owners, or the time required hasn't yet passed, then you can mention that in paragraph 12 and include a copy to say that this rule has been proposed, it's gone out to the owners, it's not yet in effect, it will come into effect on whatever the date is, unless a meeting is requisitioned, whatever the wording you would like. But point is that paragraph 12, if there's something you think a purchaser should know before they buy in, like something that you want to provide to them so that they're not surprised when they purchase, paragraph 12 is a good place to do that. All right, quickly, forms we'd like to see or change. These are just a few notes that actually I have to give credit to Gareth on this. Gareth, do you want to make a few comments on this?
Why don't we let John? I actually thought you were going last. This was me at midnight last night, so I apologize. I was gonna. So let's have John go, because I'm sure John's got comments on forms we'd like to see as well.
Yep, and we can always return to this after. So I'm going to stop sharing, and John, I'm going to pass it over to you now.
Okay, thank you. Eileen, if you're still around, I think we talked about taking a break. Did you want to do that now, or should I just go through my slides?
I think you can continue, John. We got lots of questions here, so we want to make sure we can get them all in. So yeah, go right ahead if you're okay. Okay, yeah, absolutely. So let me share my screen here. While I'm doing that, I'll just say that I did not know that I was the manager for OCSCC 5001. So that came as a surprise to me, and it's going to be tough given the board members that are listed there. I could see a lot of conflict happening.
The water slide will be awesome.
That's great. At least I can go somewhere on my lunch breaks. Okay, so part 3 here of the forms. I'm going to start out with request for records forms. So what is it? It's a mandatory form. It has to be used in any case where owners, mortgagees, purchasers, or agents of those people are requesting a record of the corporation. You know, for brevity's sake, I'm just going to call those people requesters from here on out. The records are either considered a core record or a non-core record. In general, a core record is going to be something that's considered of high importance. They're laid out in the Act, declaration, bylaws, rules, current budget, latest financial statements, audit, reserve fund plan, and so on and so on. And they're listed all in the request for records form, so you can see them there as well. Non-core records are any record that is not a core record, as the name states. So it really can be anything that is a record of the corporation. Now, why is this an important form? Just like to go over this quickly. This request for records process is now subject to hearings at the Condominium Authority Tribunal, the CAT. So if you go through this process and there is an owner who doesn't like the answer that they were given, they can submit to CAT to have their case heard by the Condominium Authority Tribunal. Generally speaking, corporations are going to want to avoid that, so it's important to follow the process correctly so that we can avoid any confusion that might lead our corporations there. I'll also mention that under Section 55, subsection 8 of the Act, there are actually penalties for not providing records. So that section does say that corporation without reasonable excuse doesn't permit that does not permit a requester to have a copy of a record, they have to pay a sum determined in accordance with the regulations to that person. So it's a bit vague, but it does say that there are penalties for not providing these records in cases where they are warranted. So very important to just follow this process to the T. So completing the form. So you can see on the right side, I've included our fake condominium corporation number 123. First thing that has to happen is the requester completes their information related to the board they're addressing, contact information, and how they prefer to be contacted. There is a separate section in this form if it's an agent of the requester. So if it's an agent of the owner or the mortgagee or whomever it may be, and it's virtually identical, so I didn't show it here, but there is a separate section for that. The requester also has to affirm that they're making the request related to their interest as a requester with respect to the purposes of the Condominium Act. So I'll just point out here that this is just a checkbox. All they have to do is affirm that. They do not have to tell your board why they are requesting this. So there are two sections in this form, the first being for core records, the second being for non-core records. So for core records, the requester has to tick off all the applicable documents. It's a list of documents that you can tick off whichever ones you're requesting. Once you tick them off, you can specify whether you want them electronic or paper version. So that's for core records. There is a bit of additional information that you have to provide for two specific types of core records. For minutes of meetings held within the last 12 months, you have to provide the additional detail of, was it a board meeting or was it an owner's meeting that you're requesting these minutes for? And again, what form do you want them in? And then there is the last section is for other records as specified by a bylaw. So corporations can actually make non-core records into core records by passing a bylaw. I've never seen it in my experience. I don't know why you would do it. I guess the only thing I could think of is if you had maybe a shared facilities and they had their separate budget, you wanted to make that a core record, you could pass a bylaw to do so. But when you do request one of those records, you have to specify specifically what you are looking for. For non-core records, obviously there's a wide range of what that covers. So instead of a list of options to tick off, you actually have to fill in what specific record you're looking for and the date range for that record. As with the core records, you have to specify whether you're requesting it in the form of electronic or paper. And if you do select electronic, I'll just note you have to select sort of a backup. So if you select the electronic form, but the corporation doesn't keep it in electronic form, you have to specify what type of paper copy you'd like to receive, whether it's examining it in person, getting one mailed to you or delivered to you, or picking up a paper copy. Okay, so we're through that process now. The owner or the requester has submitted their request for records, and it's now time for the board to respond. So again, this is a mandatory form that the board has to use to respond to these requests for records. I'm going to go through it, a bit of timeline stuff here in a second, but the main thing that I would keep in mind as a board member is that you do have to respond to a request for records within 30 days. Again, if you don't do this, you're probably opening yourself up to being brought forward in front of the Condominium Authority Tribunal. So best to deal with this within 30 days. Anytime I'm dealing with a request for records and we have a new board or a board with new members on it, I will show them a helpful flow chart that was developed by the ministry that guides owners and boards through this process. So I've included them in the slideshow here. So you can see it's very simple to follow. The requester submits their form. Okay, then it branches off into whether it's paper format or electronic format, and then goes on from there. This is where I'll note that there are some differences in timelines here. So this is specifically for core records. So you have 30 days to respond to a request. But if you have if you keep the record in paper format, if it was requested in paper format and you have that 30 days, you respond, the requester responds and pays any applicable fees, you then have 7 days to provide that requester with the with the record. It is different with electronic format, and again, as we move on to the non-core record spreadsheets here, you'll see that the timeline is different as well. So just be mindful of that. Depending on what type of record you're requesting, the timelines will be different. So in filling it out, obviously the board has to fill out the information related to the original request. Who requested it. In this case, it's our good friend unit owner, and what they requested, either a core or non-core record, and the date range. And then it's time to make a decision. So the board is able to decide that the owner or the requester can have the record, or that they cannot. But if you deny it, you do have to provide a reason for that, and you better make sure that it is a good one, because again, you risk penalties under the Act, and you also risk going before the Condo Authority Tribunal. In this case, in this example I have on the side, someone has filled out a request for a record for the superintendent's annual performance review, and the board is denying it, because one of the reasons you can use to deny a record is that owners aren't entitled to review records relating to the employees of the corporation, except for the employment agreement itself. So you couldn't get an annual performance. If the record request is approved, then we move on to the next section, which is the method of delivery and possible costs to the requester. So method of delivery, there's 4 different ways that can be specified for the delivery of the record. You have electronic delivery, paper pickup, and examination in person. So on the right side, you'll see some examples. If it's electronic, you fill that into the form, it expands for you, and you tell the requester how you're going to deliver it to them. Usually it's going to be at the email address that they provided you, although it could be through another method of electronic communication. Perhaps the board has elected to do their electronic communications with faxes, if they are stuck in the 80s or something to that effect. For paper delivery, once you select that, you have to provide the requester with how you're going to deliver it to them, whether it's the address they provide in the request for records or a different address. For paper pickup and examination in person, you have to tell the requester when and where this is going to be available for them, either to pick up or to examine. Okay. Now, costs. I had mentioned the costs of request for records. So the board does have the right to charge some costs for a request for records, depending on the type of request. There are some where you can and some where you cannot. And the cost that you charge can only relate to printing costs or labor costs. Once the costs are outlined, the requester must advise the board whether they want to proceed with or abandon the request. Perhaps they don't want to pay for it and they want to abandon it, and that's fine. But they do have to agree before you provide them with the records. So a couple of things. The ministry does specify, or the Act does specify, that cost for printing can't be any higher than 20 cents per page. And the labor cost must be a reasonable estimate of the costs that a corporation would incur for labor and printing. So this is not a profit center. This is not something that you can make lots of money off of. This is only to recover your costs. It has to be fair to both sides. When charging fees, you have to keep in mind that you cannot charge fees for a core record that's requested in electronic format. And that's the same whether the corporation delivers that record in electronic format or not. Whether the corporation keeps that record in electronic format or not. So that's a good reason probably just to digitize all of your core records so that they are in electronic format. And another scenario where you can't charge is a core record that's made available for in-person examination. Okay, so we've submitted this response to the owner. They're responding with their intent to proceed. And then we have a waiver by request for the records, which is the next form. This is a form that would be rarely used. Usually after the person responds, pays their fees, if applicable, and the board will just send them their record. But in rare cases, there may be more complex situations where the requester and the corporation agree to an alternative of some sort for the requirements associated with the request for records. I've never been through this personally. I've included an example on the side here where, say, someone has requested particular legal bills related to a rule enforcement. And we know that we have to redact that. But that's going to be a bit complicated because it is legal. We want to make sure that it's redacted properly. let's say in this case, you might want to go to a lawyer to have them redacted, and that lawyer is going to take a bit longer to get back to you than this 30-day time period you have to deliver it. So you may want to agree that, for instance, it's February 24th, and in the example here, we're giving until June 1st to deliver those records. So this is just a form that you can use to agree to those alternative, those alternate arrangements. Continuing on with the records forms, we have the records notices relating to record of owners and mortgagees. So this is an optional form. This is the first one we've had that is an option. It may be used by new owners to provide the condominium corporation with their name, unit, and address for service. In my experience, this form is actually pretty rare. Most corporations, because this form was not required previously, most corporations are going to have a resident information form that their owners will have used in the past to fill out their information. And typically, I would say that those are continued to be used. And it is okay to continue using those if you want. But what this form does is allows an owner to identify their unit in one of four ways. Usually, you're going to give the address of the unit. If you have a really good memory, you could give your property identification number with the land registry office, or you could give your unit number, level, and the corporation. If we're talking about a common element corporation, where instead of units we have parcels of tied land, well then you'd just describe your parcel of tied land. Here's an example of that form. It's fairly simple. Like I say, we put in our name of who is submitting the form. In this case, it's Mr. Recent Purchaser. They fill out the address and they give their address for service to the corporation. Notice relating to the record of mortgagees. I'm not going to share this form with you because it is virtually identical to the one we just saw here, except that you're identifying the mortgagee because the mortgagee does have a right to be registered communications and even attend and vote at AGMs. So yes, that form is exactly the same as before and filled out the exact same way. Moving away from records and getting into some of the miscellaneous forms, we have an agreement to receive notices electronically form. This is again optional. Corporations can send notices by fax, electronic mail, or another form of electronic communication if they pass a resolution confirming the method that they will do so. In most cases, it's going to be by email, at least in my experience. And then if the owner agrees in writing to receive service by this method. So this form is really for the owner to agree in writing to receive service by an electronic method. I say it's optional and I say it's rare in my experience because a lot of times what I've seen is that corporations will create a very similar form, but there's lots of stuff pre-populated and it just saves everybody a little time. It's always going to be for the same corporation. So the corporation is filled in. All people have to do is put in their email address and sign it and send it to the corporation. But this form, getting into this form, the owner does provide their email address or their fax number or the way for them to be contacted if the corporation selected another method for electronic communication. And then they agree that they're adequately served under sections 54 of the Act dealing with delivery of these notices. The summary of lease or renewal form. Again, this is an optional form. The reason it's so it deals with a form. It's a form that owners use to provide the condo corporation with the required lease information. In case you weren't aware, owners are required to provide this information within 10 days of entering a new lease or renewing a lease. So they do have to provide us with this information. This form is optional because it doesn't have to be this form. You could actually provide your corporation with the actual lease as well, and that would be just as. Why is this form important? There's two reasons. The main reason is if there's a default of common expenses from the unit owner, Section 87 does allow on written notice for the corporation to collect money directly out of the rent that's collected by the owner. So the corporation can collect the lesser of the amount of the default, the amount they owe to the corporation, and the rent. So if they owe more than the rent, then the corporation takes all of the rent. But if they owe less, they only take the amount that is owed to them. I have done this before. It's again, you have to submit a written notice to them. Usually you would be working with your legal counsel to do that, to make sure that everything is covered and you're doing it the correct way. And then you collect funds from those people. It's a great way if you're dealing with an owner who is behind all of the time and can't pay you for whatever reason. Usually in this case, the unit is liened, and you want to collect some funds to try and help reduce that default or corporation. The other reason it could be useful is in short-term rental buildings with short-term rental prohibitions. If you're not allowed to do short-term rentals and you're dealing with an owner who is doing them, this is a good form to use to get them to actually comply with the rules. So in the case I'm talking about, which I've dealt with a fair number of times, someone is doing a short-term rental and they know that it's not prohibited in the building, or that it is prohibited in the building, but they say, no, I do have it's a long-term tenant that's in there. I am renting it, but it's a long-term tenant. Okay, well, let me see I'm going to need to have a copy of the lease. And if there's any resistance, you can say, well, there's this summary of lease form. You don't have to give me the full lease, but you do have to give me the details. And it can just force those people who are doing short-term rentals to fall in line with the requirement to provide a full lease or a summary of that lease. So what does the form look like? Here it is on the screen. Section 1, owner provides the corporation with all of the lease details. We can see here that our owner is leasing to Mr. Terry Tennant. So providing the details, the phone number, the commencement date of the lease, the termination date, what option to renew on the lease, and then how much are the rental payments on this, and any other information that they want to provide. Section 2, the owner has to attest to the fact that they're providing the lessee or the sublessee with a copy of the declaration, the bylaws, and the rules, which is just to make sure that our tenants are following the rules the same as any owner would. And finally, the owner does have to agree that provide notice to the corporation if the lease is terminated. The last form that I have to go over here, notice of future funding of the reserve fund. It's a mandatory form, much like Christy was saying with the status certificate form. I don't want to get too deep into it because it's a pretty big form, but I will summarize things for you. So it's a form that's used by directors to notify owners of a plan for future funding of the reserve fund has been proposed. It has to be sent to owners and the auditor within 15 days. Within 15 days of the board proposing that plan for the future funding, and in most cases, it's not going to be a board or manager that fills this out. It's actually going to be the reserve fund planner. What's involved in the form? It identifies a summary of the reserve fund study. So your opening balance, your assumed inflation and interest rates, and then it gives you a cash flow table over 30 years. It'll provide you with a summary of the proposed funding plan, mainly a contribution table for owners to see what the proposed plan is, how much they're going to be contributing, and then any areas where the reserve fund study differs from the proposed plan for funding. And I'll come back to that point a little bit later. So here's the form. Again, it's a big form. I hope you can see it. You can see those 3 sections. So there's the summary of the reserve fund study, the cash flow table over on the right side, and then the summary of any areas where it departs from what the reserve fund planner came up with. And this is just the continued portion. So why is this form important? It allows owners to understand their contributions to the reserve fund. A lot of people may not look at this in actuality, but you will have owners in any corporation that's going to want to know where their money is going. So this tells them that. It's a good use for budgeting. If you're preparing a budget for your corporation and you need to know how much you're contributing to the reserve fund next year, you can just take it right off the funding notice of future funding. And then it's necessary to follow this to ensure that funds are available for capital projects. And coming back to that third point, the takeaway: trust your reserve fund planner. This is not a good idea to mess around with the reserve fund plan. You know, you're going through your reserve fund study, you're dealing with your planner and trying to come to an agreement on what projects are going to be done when. But when it comes to the plan, in most cases, you're going to want to go with what that reserve fund planner is telling you. As we know, other protections under the Act, if you follow the advice of an expert, and this is one case where you would probably want to do that. So Eileen, that's the end of my presentation. So maybe we can go back to those forms that we would want to see.
Yeah, thanks, John. That was really, really good. I'm kind of with Christy earlier, was kind of like, oh, a presentation on forms. You know, this might be kind of dry, but you know what? This was, I hope everyone else agrees, it was pretty useful. Thank you guys so much. Very handy. So I know Christy and Gareth, you guys had a list of forms you'd like to see.
Yeah,
What does that entail?
Oh, so let me just share my screen.
I think the rest of us are going more forms.
Well, actually, you say that. More forms, potentially fewer forms. It would be great if there were fewer forms and the forms that we have are a little bit simplified. I think we all saw that, you know, you click something and it expands, blah, blah, blah. Maybe you can have it so you click a form and it's very, very simple and only expands when you need certain things. Like it doesn't, like that auditor about removing the auditor thing. Maybe you don't see that. So potentially forms that just click and display only what you need, simplified. Director disclosure form. Director disclosure, we mentioned, I think Christy mentioned it's mandatory. It would be lovely if there's actually a mandatory director disclosure form you could include with your meeting or your preliminary notice. Here you go, fill this out, send it back so that we've got it and we don't have to do any director disclosure at the meeting. Be lovely if the notice of meeting form was kind of rejigged for special meetings. You don't have to send prelim notice for requisition meetings or where the condo does a meeting if you've lost quorum on the board. Just be lovely to have something on there so you don't have to do a cover letter that says, by the way, we're sending this without a prelim notice because. And then, John, we talked about this. It'd be lovely if there's kind of a simpler response to a core records request where somebody has only requested core records and you can just fire them a simpler response.
Yep.
That's what and then consent for deck amendments, that's a kind of esoteric thing. But that's just what we had thought and kicked around as we kind of went through. And I mean, for me, like, we don't always look at these forms, but when you start looking into them, okay, we had this problem that time or whatever. There are areas where the government can improve their mandatory forms. That is for sure.
Maybe John's board at OCSCC 5001 could help.
It's a matter of provincial jurisdiction, unfortunately.
True. Maybe they could get the push. Maybe how about that?
Yeah.
Excellent. You know what? We have quite a few questions coming in here, and I've been looking at them as we've been going along, and there's a lot of great questions. So let's see if we can get to them all so we don't have to keep everyone here all evening, but we have some great questions. And I think this, Gareth, goes to your point of making better forms. We've got one from Brian that says he has a Mac and he hasn't been able to fill out several of the forms, and therefore he has to print and complete them.
Make sure your Adobe Reader is up to date.
Okay.
I mean, they're all PDF forms. Make sure your Adobe Reader is up to date. And if you are printing and completing a form by hand, please make sure you expand all the check boxes that you need to expand so that the other comment boxes or whatever it is, the fields are there.
And just to jump in, Eileen, there, I've noticed myself that if you're trying to access these forms from any sort of mobile device, I've never been able to do that. And I think that's probably what's being referred to here. So maybe there is a way to do it, but I've never been able to do it. So, you know, try and open them on a laptop if you can.
Oh, good tip. Good tip. The next one we have here is, what if something changes between the issue of the preliminary form and the notice of meeting? An example is perhaps a new item on the agenda. Do you still need to restart? Gareth?
It depends on what's changed. And I think there's another question about this. Oh, we didn't put the bylaw on the prelim notice. Yeah, you've got to send out a new prelim notice. The Act and the regs are very clear that everything that's coming before the meeting has to be on that prelim notice. Depending on what the agenda item is, if, say, you want to include, say, a discussion of the president's report, well, that doesn't have to change your prelim notice. But core things that have to be set out, changes to your declaration, changes to your bylaws, changes to your rules, some of the director voting, you may have to do that. We've seen cases, and Christy, you've probably seen these as well, where you've got one vacancy on the board and then somebody resigns or whatever in the interim. You say, okay, do we have to send out another prelim notice because there's a second vacancy? Arguably, well, yeah, you do, because there's now extra space for people to run.
Okay.
I don't know if Christy's got strong thoughts about that.
Yeah, these issues are always really tricky. Yeah, so it's tough and definitely depends on the circumstances. But I can say one thing because I just dealt with it recently. If your meeting date is changing, that's okay. So if your prelim notice gave you a particular date, but you're changing the date by a day or two, that's okay. The notice of meeting can just confirm the new date. Always good to like flag it for owners by maybe including it in a cover letter or something to say, FYI, the meeting date is now this, and the preliminary notice said that, but in case that was a burning question for anyone.
Okay, excellent. So our other one, Gareth, maybe you want to take this one. They're looking at changing an auditor that was appointed at the last AGM. What did they do?
Auditors are reappointed every annual general meeting. So you don't really need to do any sort of removing the auditor in that case. You just have to, the condo has to put forward a new candidate or candidates to be the auditor. And you've got space in your notice form to set out who the board is nominating.
Perfect. John, you probably hear this one a lot. How long do we have to keep those proxies after a meeting? What do you guys think?
I think, especially, I think the confusing part comes with the electronic proxies now, and how to get those destroyed or not. But maybe Christy or Gareth, you could jump in. Usually it is 90 days from my recollection. Yeah. So
For
90
proxies
days
and ballots.
Yeah. So one thing when I'm talking about electronic meetings, we've probably all done at this point, you may have to go to your electronic meeting provider and actually ask them to destroy those electronic proxies for you after 90 days.
Good to know. Garrett, this one is on your meeting forms here. They say, please explain the vote order on the proxy form. So is there a voting order?
There is, and that's for the person filling out the proxy form to complete. If I can share my screen, we can actually put up a proxy form again. Because the proxies are actually ranked choice forms. There we go. And where's our proxy? Yeah, sorry. There's a ranked choice order of vote. Right here, 1, 2, 3. So it is important when folks fill out the proxy to fill them out properly to say, I want, number one, first choice, second choice, third choice, although most people typically, they only vote for 2 people. If there's 2 people where you've got a conflict where somebody's filled out for 3 and you've only got 2 positions, typically, I think you just have to go 1, 2 as to how it's laid out on the form. I don't know if Christy's got a different method. This is something that you don't see as much because we're using fewer paper proxies these days, but it's a good question.
Very good question.
So please remind when you instruct your unionists, please remind them to fill out their choices only for the number of seats that there are.
Perfect. We have the next one here. It says they apologize. But did I hear you say that all the condo docs to go to the notice of meeting, the declaration of bylaws with the regular full AGM package?
No, sorry, I was talking about our fictional meeting for OSCC 5001 because they were doing a deck change and a new bylaw. The changes to the declaration, the new bylaw had to go out with the meeting package, but not your already registered condo documents do not.
Perfect. We have, what if pass a new bylaw was not included in the preliminary notice? That's a good one. What do we do there?
I think we had the version of this question before. You will have to do a new notice or preliminary notice. It's fatal to the process.
Exactly. Perfect. This one's a self-managed corporation with 15 units. They have all owners completed exemption from issuing all forms. Oh, it scrolled up on me. Sorry. Let me get that question back. In place of the official form, we use a newsletter that contains all the relevant information. Is that still legal as long as we have fewer than the 25 units? Christy?
Yeah, I'm assuming that this relates to the PIC. So the ministry really likes to see the ministry's forms used. I will say that. They don't like it when people mess with them. I think, though, substantively, if the information is the same, arguably it complies with what's required under the regulations of the Act. I think I heard you say, though, Eileen, that this is one where the owners, it's a smaller condominium, obviously 15 units, and they've got exemptions for the form. So just to go back to the exemption, what is required to be exempt from the need to send out information certificates is that 80% of the unit owners have provided their written consent to waiving basically the requirement for the information certificate. So if the owners have done that in this case, and I guess it would be 12 units of the 15 would have to provide that consent in writing, then they're not required to provide any information certificates, and the newsletter is certainly more than enough. But the exemption only applies from year to year. So the owners have to provide consents every fiscal year in order for it to be effective.
Excellent, thank you. So this is another one on proxies. So they're asking if the directors can do the same as managers regarding the proxies since they don't have a manager.
I assume this is about kind of solicitation. Managers are, or sorry, directors are not restricted in what they can solicit votes for. Directors are political creatures and they can of course go out and try to get people to vote however they want. And if you don't have a manager, yeah, please help everybody in your building complete the proxy properly. You're educated now.
And Mark wanted to know if they could, everyone could get a copy of this presentation. What we're gonna do is we're actually gonna post this webinar on the CCI Eastern Ontario website. So you can actually have another look at it there and share it with your fellow board members or fellow owners at your condominiums as well. Then we have Carrie. She's asking, why not just send out board meeting minutes like they do in other provinces rather than an information certificate?
Well, it's a good question. The short answer is because the law requires it. So there's no way around it at this point in time. I know a lot of condominiums are posting board meeting minutes on like owner portals to make those available to owners. So that's certainly useful information and may be more relevant, more interesting to owners in any event. But yeah, the short answer is because Doug Ford and his government, well, actually, it's not his government. We shouldn't blame Doug Ford, but the government requires it.
Perfect. We have another one. If the board member does not change at an AGM, is an information certificate needed to be sent anyways?
So if there's no change in the board makeup at an AGM, is that the question?
It seems to be, yes. Yep.
Yeah, so I mean, it depends. If there was a vacancy and the same person got elected, I think it would probably make sense to provide that information in a in an information certificate update. It seems ridiculous because you're just basically telling owners, yeah, the board hasn't changed, but like there was a vacancy in like technically there was a vacancy and then it was filled by, I mean, owners might want to know who was it filled by. It was filled by the same person. So I think probably yes, my answer would be that an information certificate update should go out in those circumstances.
Excellent. So Chris is asking, when an owner seeking a position on the board and has a claim against the board of the corporation, the owner must include this on the director's disclosure form. However, the space is not large enough to input the information and most probably may not catch the attention of owners to be aware of the conflict, and therefore may not take this into account in section 1 voting regarding candidates. Did you guys have some thoughts on that statement?
Sure, a couple. I mean, there's obviously no mandatory director disclosure form. So you can attach extra pages to it and you can attach extra stuff to whatever goes out with your meeting package. About disclosure, they should fully disclose whatever it is that's going on. And that's kind of where it needs to live. And a good meeting chair says there are director disclosure forms in this package. I hope you've all read them and maybe update that as well. You generally, and Christy can correct me, generally don't point out that somebody said, well, oh, they're suing the condo. unless, of course, they're offside of a qualification bylaw for being a director.
Lana has a good question. Can the address for service for the directors in the PICs be the service address for the condominium corporation?
I know that's sort of that, including the address for service for the corporation or the manager's address, care of the management company, is not uncommon. I think the technical requirement is that the address for service of the individual, so basically their residence be included, but there are a lot of concerns about disclosure of privacy and whether or not that's actually required. And there's nothing in, I actually looked at this today because I anticipated this question, and there's nothing in black and white confirming that that's a requirement. So I think it's probably okay to include the address for service of the corporation.
Okay. We've got here, it's to continue with section 1, voting regarding the election of candidates. Could there be a comment box to include mention of the conflict of a particular candidate? Gareth, what do you think?
I think that goes back to the answer about director disclosure. It's in the director disclosure form. They have to disclose their conflicts. If at the meeting, you know, they haven't disclosed whatever it is and somebody thinks there is, well, it's for a unit owner to bring up at a meeting. It's, that's kind of where that has to live.
And then we have, if an owner checks off all 3 boxes for 3 candidates, but there's only a vote for 2 candidates, is a proxy void? And that question just went away.
I'm so sorry. Sorry, that was, I fat fingered the mouse. I apologize.
That's okay.
The question was, is the proxy void, or do the first 2 candidates, first 2 names get selected? I think we talked about this earlier. You're probably going to take, and this is paper proxy only, the first 2 candidates. Most electronic proxies will error trap for stuff like that. So it's another good reason to push people to use electronic proxies.
Okay. So the first 2 would be valid. Dawn says, our declaration has a Schedule C that describes the boundaries of a unit, but there's no standard unit bylaw. Is that sufficient? It's a little off of our forms, but maybe Christy, you want to take that one?
Yeah, sure. I think that probably came up because one of the forms I was going over references the standard unit bylaw, whether or not the corporation has one. But the short answer is no. So the standard unit description is relevant to insurance, and that's a whole nother topic for CCI to cover in one of its many seminars. But the unit boundaries are not the same. The short answer is that they're not the same, that the standard unit description needs to stand alone, either by way of bylaw or by way of standard unit description that was provided to the corporation by the declarant at the time of turnover. Sometimes it's just a piece of paper that's included in the turnover documents, and it's not actually registered as a bylaw. It's actually still a valid standard unit description. But that's the only way to have a standard unit description, is one of those two ways.
Perfect. Our next question, do all actions, example, mediation and arbitration, require that they be identified in the PIC?
So mediation, no. Arbitration, I would say yes. So if an a notice of arbitration has been issued and served either by or on the corporation, then that would have to go into the PIC.
Perfect. Mark is asking, what happens if your insurance changes in the year, re the deductible changes?
If the deductible changes, that is something that triggers the information certificate update. So if it changes between when PICs are due, then you would have to provide that information to owners within 30 days of the change, or notice to the corporation of the change.
Okay. Brian's asking, and if they were told that by their property manager that during COVID, the issuing of PICs was suspended. John, maybe you want to step in on this one. Was this an accurate reply to them, direction?
Sure, yeah, I can step in there. The answer is you still have to send out the PICs. You're still required to send out the PICs, despite COVID. I know COVID has, there have been some temporary adjustments under the Act for electronic meetings and other things, but you do still have to send out the information certificates.
Perfect. If an owner requests a count of AGM votes for the past amount of years to compare the number of votes to proxies to the current year, how far back is reasonable to provide this information? Gareth, what do you think on that one?
I think that's an incredibly complex question. That's what I think. So I think, John, you mentioned, somebody asked, how long do you have to keep these for? Ballots and proxies, you got to keep them for 90 days. But then you've got a question of, well, were they destroyed? If they're destroyed, we've got them, so potentially they are a record still. And then you've got to look at kind of what happened in previous years. Were they destroyed? And stuff that happened before the current act came into force. You guys, everybody might remember that you usually did a motion to destroy the ballots as well. So you've got to kind of look and see, do these records exist? What's happened to them? And what are they asking? It's very fact specific. Contact your condominium's lawyer. Because lawyers always love records requests. No, we don't.
John, you're with me. We don't like them either, do
Oh,
we?
no, yeah, not our favorite, that's for sure.
No. Perfect. Doesn't annoy just involve duplicate work? I imagine compared to the PIC and the ICU?
In sort of, annoy doesn't go to all owners. Annoy only goes to the new owner. So when the corporation receives notice from a new owner that, hi, I'm a new owner, this is the unit I purchased, then the corporation is required to provide that owner with a NOIC. But the NOIC is just like a cover page that has attached to it the most recent PIC and the ICU. So really what you're doing is just bringing that new owner up to date with the information that you've most recently provided to all of the other owners.
Perfect. And the next one from Jerry goes to contemplated repairs and possible expenses and disclosure. So if the board's discussed upcoming major repairs without implementing, are they obliged to inform new owners of these upcoming expenses in the status certificate? Paragraph 12.
And that's where I would put it for sure. You do have to disclose it as soon as you're aware of it. You have to disclose it because the purchaser really needs to know that when they're making a purchase of a unit.
Yeah, any possibility of any possible changes in the common expenses should definitely be declared in the status certificate, even if it's not 100%. Dawn wants to know, can a developer or prospective purchaser of a phase condominium request a status certificate for a unit that is in a phase that has not been turned over?
Anyone can request a status certificate for any unit of any condominium corporation. I think the question, and it sounds like if we're talking about hasn't yet been turned over, it suggests to me that the phase has come into existence. So an amendment to the declaration has been registered, creating the new phase, but it hasn't yet been turned over because not enough units have been sold. So if that's the case, then the unit does legally exist and therefore a status certificate can issue in relation to it. If, though, I've misunderstood and the phase has not yet come into existence, it's just a proposed phase, it's still being developed, it hasn't yet been created by way of an amendment to the declaration, the unit does not yet exist, the phase of the corporation is not yet condominiumized yet, so you can't issue a status certificate for it. But you could probably ask the declarant for a disclosure statement, if you're interested in purchasing the unit, or suggest you're interested in purchasing the unit. That's one way of getting information on the particular unit.
Perfect, thank you. Michael just wants some clarification on common expenses. Do they mean assessments?
If it was a reference to the way I was using that word, then yeah, so common expenses and assessments are really the same thing. Now we often refer to special assessments as like common expenses we refer to sort of as like the monthly common expense assessments, whereas special assessments are sometimes one time only or just a couple, like they're unusual. They're not the regular monthly common expense assessments, but yeah.
And this this attendee wants to know if the board sees all certificates or only one per board meeting. So imagine when the manager does their meeting package for their board to see, they want to know if they see all of them or just one. What do you guys think on that?
So typically when I'm preparing a board package, I'm going to put in what I call a pro forma status certificate, which is essentially a blank, well, not blank because it's filled in with the information specific to the corporation, but it doesn't reference a specific unit or a specific status certificate that was already issued. So in essence, you're getting the board to approve the information in the status certificate, not a particular status certificate for a specific.
Excellent. Our next one is not a question, but it's a kudo for Christy. She says, they say, I just love that Christy girl. So there you go, Christy. Great presentations tonight.
Thank you to whoever that is. Obviously, I've paid for that endorsement, but
so we have one here. Is there consideration that the cost of issuing a status certificate will increase above the $100 in the 10-day time frame anytime in the near future? $100 doesn't seem adequate, in particular since there's such a demand for them due to the current sales market.
I can take that one, I think. So yeah, the Act specifies, or I mean, the standard charge is $100, but there's nothing in the Act that says you can't charge more for a different time frame. So I know most managers, including Apollo, if there's a request for a rush certificate, which is really kind of becoming the norm now, and given Ottawa's market, then there could be additional charges to produce it on a rush basis. But right now, for a standard status certificate request.
Okay. Our next question, did you just say that an owner requisitioning records does not need to give a reason why?
So yeah, that is correct. And I actually put that in because I heard it on a podcast that Christy was on. So yeah, they don't have to say why they're requesting the record. And I think this is probably in reference to the fact that one of the reasons that a board can deny a records request is if it's related to contemplated or actual litigation. So you could be referring to someone who's collecting that record for their litigation against the condo. But they still don't have to say what they're requesting it for. Correct me if I'm wrong there, guys.
That's correct. Our next question comes from Kitty. Our corporation is considering the remediation of fences due to encroachment issues on several of our units. Fences have been installed by owners outside the standard unit. They have received legal counsel. However, before they proceed, they want to know if this needs to be included in the status certificate. Cost will be the responsibility of the corporation.
Talk to your legal counsel about that one. Sounds like you've got condominium legal counsel. And it sounds like it could be a potential Section 98 modification to the common elements issue, which usually you have to disclose Section 98 agreements on status certificates. And if there's kind of illegal or unforeseen modifications, you always err on the safe side and disclose, but talk to your legal counsel first, because that's a very complex question.
Yeah.
Outside the scope of this presentation.
Yeah, very specific to that condo. That's definitely a good question for that condo's particular legal counsel. Our next question, if a board does not receive proxies, for example, 2 out of 10 owners, and there's going to be a vote on a bylaw that at an owners meeting, does that mean the board needs 4+1 votes for it to pass instead of 5+1?
No, depending on the type of bylaw. Most bylaws, you need a majority of all the units in your condo, regardless of whether or not they show up. So for your 10-unit condo, you've got to have 6 units to pass a bylaw. Some bylaws can be passed under a lower threshold, electronic meetings bylaws. And Christy can tell me there's another one, I can't remember what it is. And those are passed on a majority of all the units at a meeting, so long as you've got quorum. I think there's another one with a lower threshold. But it's e-meeting bylaws are the big ones you can do on a lower threshold. But regular bylaws, which is almost every bylaw, standard unit, insurance, whatever it is, you've got to have a majority of all the units in your condo vote in favor.
Thanks, Gareth. Chris wants to know what's the time frame that the records information to be provided is.
Yeah, so I would put you back to that that flow chart that I gave you from the ministry, because there's a few different answers here. Generally speaking, it's going to be once the person pays their applicable fees on a request for records, it's 30 days. But there are cases, like I mentioned, with a core record that is kept in paper form. That one is 7 days after the board responds. But generally speaking, it's going to be 30 days. But given the breadth of possibilities out there, I would refer to that fast facts at the minute.
Perfect. Thanks, John. So if somebody owns more than one unit in the same building, do they need to fill out separate proxy forms? Marjorie wants to know.
Depends on how the meeting's being run. It's really down to the meeting chair. Usually the best thing to do is fill out a separate proxy for each voting unit that you own. Your electronic meetings provider, I think most of them do it as, one vote per unit tied to the email address that's tied to the unit. So probably yes, unless your meeting chair does something, especially we've got, condos where people own large blocks of units, and then you can actually do stuff because and everybody knows that this proxy represents 50 units, this proxy represents 25 units. Depends on your meeting, but safety, one proxy for each voting unit.
Okay. And what about requests for records? Can somebody make a broad request for records for copies of all contracts and all invoices? And must this be complied with? Mark wants to know.
Yeah, so certainly they can request it. You can't stop anybody from requesting anything. I kind of answer this in two ways. If someone wants, and I'll let the lawyers correct me if I'm wrong, but if someone wants all invoices related to X, I think that's a fair request. But there is a point at which something might be considered a fishing expedition. I want all emails relating to discussions of this thing that happened in our condo, or everything related to water infiltration over the past 7 years. Those are not requests that need to be complied with. So I guess it depends on the level of specificity. And if you're not sure, talk to your condominium lawyer.
Correct. There's a lot of condo authority tribunal case law on what's phishing versus what's not. I actually had this come up recently in a condo. They said, we'd like 10 years of all the HVAC service contracts. And you kind of turn around and say, well, A, do you have it, condo? Because the easiest thing to say is, do you have it? And B, okay, if you need to get it, you got to put the cost together. For contracts, the retention period for contracts is, I believe, 7 years. And so you should have, every, say, like cleaning contract for the last 7 years, you hope is on file. But generally you're going to give them.
Excellent. So Peter's next here with his question. And he wants to know if board minutes are still in draft form. Do they need to be provided as a core document before they're approved?
Oh, no, I see Greg shaking his head. If something's in draft form, you don't have to provide it.
Excellent.
And really, nor should you.
Yeah.
Yeah.
It's not a record until it's approved by the board.
Correct.
Perfect. If there's a cost associated with retrieving records, is the owner responsible to pay these charges, or is it the corporation's responsibility?
So it depends on the type of record. I did go over a couple of records that you can't charge fees for, but generally speaking, you can charge reasonable fees if there are costs included for labor and for, and whether that be redacting or what have you, and printing costs. And that would be payable by the requester, not by the corporation.
Yeah, and I'll just dovetail onto that. And this may be, you've got to pay somebody else to get the records out of an offsite storage, or in this HVAC case, one of the HVAC companies came back and said, we can put these together, but there's a cost on our side to get these. I think it's reasonable to pass that on to the owner, especially if it's outside of what the board or the condo has to maintain.
Excellent. So Christy, Lorraine wants to know, do all status certificates require board approval?
That's a good question. a board could decide that that's how they want to do things in terms of issuing status certificates. So the board could decide that each and every status certificate that goes out requires board approval. Practically speaking, that may not make a lot of sense. And, especially when you consider the 10-day time frame. So the process that John had summarized earlier is sort of the standard practice where the contents of the status certificate are provided to the board at each board meeting for approval. Obviously, if there are changes between board meetings, then there can be communication between the manager and the board with respect to what updates are required. But otherwise, I think the standard practice is that the contents go to the board at each board meeting for approval, and then between whenever a request is received, the manager prepares the specific status certificate and issues that on behalf of the corporation.
Perfect. Lorraine has a follow-up question too about the status certificate of whether a rule like no Airbnb short-term rentals should be included in that.
Always go with the status certificates. But it's not a bad thing to, I guess for rules that might be unexpected, although I will say like those short-term rental rules are fairly standard now, I would say. So it's not as much of a shock. I remember when we first started creating those rules and giving them to our condominium corporations, at the time we advised them to include in paragraph 12 a little note to say, FYI, we have a rule here with respect to short-term rentals. Please take a look at the rules attached. I don't know if that kind of flag for purchasers is required anymore because it's not as unusual. But anyway, it is an option to flag particular rules that are important to the corporation that might be a little bit different within paragraph 12.
Anything related to smoking or pets
Yep.
is what you're going to see generally.
Correct. Like make it blatant for people that there's a dog restriction or that there's a smoking or cannabis restriction. Just to even help them on the front end so they can figure out if they want to live there or not.
Yeah. Mark wants to know if an electronic signature is okay on these documents.
A lot of the documents that I presented didn't even need a signature, to be honest. If you're submitting a request for records, you don't have to put a signature on it. When an owner is responding to a board's response and confirming they want to go ahead, they don't have to put a signature. They just have to put in a printed name. I can't think of any that actually require a signature.
Proxy forms require signatures, and electronic is absolutely fine. On, I think, any form, in my view, if you've got an electronic signature versus wet ink, it's fine.
Our next two questions are about leases and the information the corporation gathers with regards to leases. So the first one's asking, why do we need to collect the monthly lease amount? Is it because of Section 87?
Yes, that's why you're going to collect it if you need to collect that. If you end up in a situation where you need to collect that rent right from the tenant. Christy, it looked like you had something you wanted to say there too.
No, I had a moment like Gareth with the fat fingers on the mouse.
Yeah. Yeah, no. So
but I will say I totally agree with you. So
yeah.
And that's only so long as the, I guess, notice or the unit is in arrears. Right. Condo managers obviously don't normally collect the rent, but you can attorn the rent if the unit is in arrears and all the proper notices have been sent.
Perfect. And what power does a board have if an owner refuses to provide that lease or the summary?
I guess in practice, you'd probably be in a similar situation to a rules violation. You'd be requesting that information from the owner and insisting that you have to have it, telling them that there's a timeline. And if it gets difficult, then probably you're going to go to your legal counsel for assistance.
Perfect.
Absolutely. We
have a lot of great questions coming in on forms. Really do.
Everybody's informed.
Yeah. Whoa, there you go.
Sorry.
Doesn't love a good dad joke.
Yeah.
Monica wants to know, does the board need to vote to release records, or is it okay for management to release some records?
Request for records form right now actually has to be by resolution of the board that they are approved. you know, personally, like I've said, like Gareth and I had mentioned, there'd be some records where we'd like to see that the manager could just send those off, like you know, insurance deck bylaw and standard unit bylaw. It'd be nice for people who have had an insurable loss to be able to just have them sent to them. But I believe it does say that they have to be approved by board resolution at this point.
Our next question asks, on the proxy, if the president is up for election, can or should their name still be default on the proxy form?
So your president is actually the president of the corporation until the meeting is terminated. Your directors hold office until that meeting is over, if they're replaced at that meeting. But if you want to kind of say for safety, you know, secretary, VP of the corporation, whomever it is, you can even name another director who's not up for election.
Perfect. Is the preliminary notice mandatory for requisition meetings?
No, it is not. And actually the timelines in the Condo Act don't really allow you to send a prelim notice because you've got 35 days to call and hold that meeting after you get that requisition.
Michael says here, you mentioned that mortgagees can vote at an AGM. Does that apply for AGMs only? The real question is there a vote for the mortgagees? Would that be a type of proxy? Does that impact quorum in any way?
Okay. Mortgagees, if they give notice, have the right to step into shoes of the unit owners and kind of take every step with owning the share of the corporation that the unit owner has. So they could actually vote at any meeting of owners where there's a vote. So long as they've given notice. I think one of the check boxes on the proxy actually says mortgagee. Does it impact quorum? No, you're either counting your registered owners or you're counting your mortgagees who have given you notice. And I'm going to say that I've never seen a mortgagee say that they'd like to come to a meeting and vote. Yeah.
Yeah, I don't think I've seen it yet either.
Good to know that it can happen, but I've never run into it either.
No.
TD Bank does not care who the director at OSCC 5001 is.
Excellent. If an owner is aware of errors, what if an owner, is aware of errors in the PIC or the ICU? What do they do?
Question. I think they can raise it with, like, the first step would just be to raise it with the manager or the board, to have a discussion about why the error occurred and to go from there. Obviously, it gets a lot more complicated if the issue is disagreement about the information that's going out as to whether or not it's accurate. In that case, I think it becomes a fact specific type thing. But if you see mistakes obviously happen, and so it's just a matter of communication.
Yeah, definitely let your manager know that one. It might be just a simple mistake for sure. Katie has here that at the AGM, we voted to accept the board's honorarium for the next fiscal year. Can this be an item added to the notice of meeting?
Remuneration of directors actually has to be done by bylaw. You actually have to have a bylaw. This is, I'm just grab my Condo Act. It's 56 sub 2, my very broken Condo Act. Any sort of remuneration of directors, you've got to do it by bylaw, and that bylaw is only effective for 3 years. So please talk to your condo lawyers about that and get it set up under the Act. Please and thank you. Or I recommend you do.
Excellent. So our next question wants to know who's responsible to ensure that all the forms are sent out correctly. Is it the manager, the director, or both? John?
I will say, generally speaking, under the Act, everything is the responsibility of the board, and that's why your manager should be running pretty well everything by the board. Especially if there's anything that might be there might be any questions on any of it, but it is technically the responsibility of the board. Now, there are probably some things in your management contract that will say that your manager is responsible for ensuring the accuracy of these forms, but under the Act, it is the board that's
responsible. Okay. There's a couple other questions here with regards to status certificates on who receives the fee for it. Is it the corporation or the management company? Christy?
Actually addressed within the management contract. And typically it's the manager, because the manager is tasked with the responsibility of actually putting it together. Now, if the responsibility is the corporation's to put together the status certificate for whatever reason and send it out, then it would make more sense that the fee gets collected by the corporation. But it's really the party that's doing the work that should be collecting the fee. And then the management contract, the ones I am most familiar with, typically do confirm that the manager collects the fee as part of its services, basically.
Yeah, excellent. And then also, does the property management company need to let the directors know every time a status certificate is requested? John, what do you think on that one?
I don't personally think that they need to be informed of everyone. You could probably mention the ones that are, it's probably good practice to mention it maybe at the board meeting, but generally speaking, no. They've approved the status certificate at every meeting. So if you're putting them out in accordance with what the board has approved, I think that's okay.
Excellent. So we have a few more questions here. We're getting near the end, but I think everyone's put in some good questions for us here tonight. Our next question is, if board minutes are posted on a web portal, should they be redacted, i.e. info discussed specific to one unit?
Please.
Yeah, we're all shaking our head. We're all shaking our head.
Go look at, was it 55.4, your exemptions to why you have to produce anything about individual units, owners, actual contemplated litigation, employees of the corporation, all that stuff. Please redact it. You're not supposed to be giving that out. It's actually why you should have a set of minutes, like a sheet in camera. Page 4 is your in-camera minutes. Those don't get posted. Pages 1 to 3 do.
Yeah, it's always good practice to get those 2 sets of minutes made. When you have your secretary do your meeting minutes, do the regular copy and then do your redacted version. It also saves you the headache if you get a request for records down the road. You don't have to go back and redact them all at one time. So get those 2 sets made right at that time. Our next one is, can an owner requesting records request email exchanges that took place respected to him or her if there was an issue or a problem respective to that unit, for example?
I would say, I'd be interested to know your guys' opinions, but I would say no. I know there is a case where someone requested board emails on a certain contract, and that went to the tribunal, and they sided with the board that those emails between board members did not constitute a record. I don't know if it's gotten any more specific than that as far as the case law, but I would say that generally emails, no, are not a record of the corporation. What do you guys think?
Generally, emails are not a record. There is a CAT case from last year where the manager's report was appended to the minutes, the official minutes, and that report was held to be a record because it was appended to the official minutes. So if emails are kind of appended to the minutes somehow, those would be a record. You really have to look over that with your lawyer. There's an exemption. Obviously, you redact stuff about individual units and owners, but there's an exemption to that where if it's about me, I can potentially see it. But then you get into, well, is this actual or contemplated litigation or what's going on here? Very fact specific.
Emails, if we're talking about email, like complaints from other units about my unit, I might think I'm entitled to that. I would say no, because complaints from other owners are specific to them and their unit. And so while it might relate to me, it's not something that I'm entitled to see. If and when the issue ever went to court, there's different disclosure obligations that apply once you get there. But generally speaking, that's not the kind of thing that should be disclosed.
Fun. So we're going back to proxies on our next one here. Marilyn wants to know what sort of information has to be redacted when an owner requests to review the proxies. This is a good one.
And
Christy,
the one good thing about the proxy form is it's actually got kind of the tear offs where you literally tear off the unit owner information or redact that. It's the strip along the top and the strip at the right-hand side.
Yeah,
very easy to do.
Yeah, perfect.
Just a practical tip, make sure you print your proxy single-sided. That way when you're tearing off that right side, you're not tearing off part of the other one. I've seen that done before. So.
Very good tip, very good tip. Ken says, my pick has check boxes for directors and officers boxes. is never used. So I don't know who's the president is. Should it be with the officer's position?
Would be checked off. If they're both directors and officers, they hold an office, then when you click off director and then nothing really changes within the box. But when you click off officer, a little pop-up comes up where you can enter the title of the individual. So you would enter president, treasurer, whatever the position is, and that should be completed. So that's information that could be added to the pick in that case.
The act requires a president and a secretary for every corporation, and your bylaws might require more.
Yeah, and your bylaws will actually tell you which positions are held as officers in there. So it's good to look at that and list those presidents and treasurers. Nancy has here question 12 in status certificate. Insurance, maybe paragraph 12. Insurance is going up at a crazy rate, especially due to snow removal. That is true. How do you respond to paragraph 12 where you budgeted what you thought was a reasonable increase, but knowing that insurance rates at this time are going up at an unreasonable rate? A good one. How do we address this in the status certificate?
So in a lot of my corporations, paragraph 12 has a bullet that says insurance rates in Ontario are rising more than by more than inflation across the province, and I believe it is across the country as well. So that's something that I would recommend that you do disclose. Just say that generally speaking, insurance rates are going up, and it may have an impact on your common element fees.
Christy and Gareth, you're shaking your heads agreement on that one.
Correct. Yeah.
And
that might be a bullet point that's in section 12 forever and ever and ever.
Yeah.
I think when there's industry changes that when there's anything affecting the industry as a whole that could result in an increase, it's a good idea to include that. The question is always like, when do you know it's actually an industry thing versus just in specific incidents? But yeah, it's a great question.
Perfect. We have a couple more here before we end this evening. Sue wants to know what the importance of section 54 of the Act with respect to service of documents notice vis-a-vis everyday electronic communications.
Section 54.
Sorry, I hit mute. Christy, you look like you're contemplating that one.
Yeah, I'm just looking at section 54.
Well, yeah.
Oh, okay.
We're all just looking at section 54. It's sufficiently served if given in accordance with, section 47, as the case may be. So, and section 47 permits electronic communication so long as everybody's opted in. So I don't quite understand the question.
I think it may be in reference to when they talk about everyday communications. It's not delivering notices, possibly. Maybe it's just a general email to your condominium manager.
Okay.
I mean, in that case, you don't have to, pass a resolution to say that your manager can email owners about everyday items. So I don't think that would be affected by the Act if that's the question.
Yes, Sue, if you're still online here with us and we haven't been successful in answering that question, maybe you want to clarify if we weren't helpful. We have one. Ken is he's got a statement / question here for us. He says owners are already kept in the dark and you suggest fewer forms.
If fewer forms can mean that more information gets to unit owners faster because they're easier to fill out and simpler to understand, I would suggest fewer forms. You can have 1 million forms, but if they're not filled out right or filled out quickly because it takes forever to do them, fewer forms or simpler forms may actually assist everything getting out the door and getting info to unit owners.
Perfect. You know what? We had so many questions there, lots of good questions. Thank you everyone for your eagerness in this one. And we don't have any other questions left, so I think we can conclude this evening. Again, I want to thank Christy and Gareth and John for helping out. This was very, very informative. Really appreciate it. I hope everyone that attended enjoyed it and found it informative as well. Before we go, I also want to say a big thanks to all our sponsors. Elia Associates Condominium Lawyers again, Common Ground Condo Law, Carlton Electric, Upper B, and World Financial Group. Lots of great sponsors. Thank you so much for helping us out this evening with this. Everyone's going to get a quick little survey after we end this evening. All our attendees. Hope you can fill it out and let us know how we did, what you thought of it. If you'd like to see this event again, what you thought of our speakers, we'd love to get your feedback. Again, thank you everyone for attending, and we hope you have a great rest of your evening.
Thanks, everyone.
Thanks, everyone. Bye-bye.
Bye then.